Welcome to Law Family. This video is helpful to the law students and newly practicing and advocates only. Today, we discuss about the mental cruelty in divorce cases. Some of the following points for divorce fall into cruelty and some do not. Let us discuss the points one by one. First one is on consideration of complete matrimonial life of the parties, acute mental pain, agony, and suffering as would not make possible for the parties to live with each other could come within the broad parameters of mental cruelty. Second one is on comprehensive appraisal of the entire matrimonial life of the parties, it becomes abundantly clear that situation is such that the wronged party cannot reasonably be asked to put up with such conduct and continue to live with the other party. Third one is mere coldness or lack of affection cannot amount to cruelty, but frequent rudeness of language, petulance of manner, indifference, and neglect may reach such a degree that it makes the married life for the other spouse absolutely intolerable. Fourth one is mental cruelty is a state of mind, the feeling of deep anguish, disappointment, frustration in one spouse caused by the conduct of other for a long time may lead to mental cruelty. Fifth one is a sustained course of abusive and humiliating treatment calculated to torture, discommode, or render miserable life of the spouse. Sixth one.
Sixth point, sustained unjustifiable conduct and behavior of one spouse actually affecting physical and mental health of the other spouse. The treatment complaint of and the resultant danger of apprehension must be very grave, substantial, and weighty. Seventh point, sustained reprehensible conduct, studied neglect, indifference, or total departure from the normal standard of conjugal kindness, causing injury to mental health or deriving sadistic pleasure can also amount to mental cruelty. The conduct must be much more than jealousy, selfishness, possessiveness, which causes unhappiness and dissatisfaction and emotional upset, but may not be a ground for grant of divorce on the ground of mental cruelty. Next point. Mere trivial irritations, quarrels, normal wear and tear of the married life, which happiness in day to day life would not be adequate for grant of divorce on the ground of mental cruelty. Next point, the married life should be reviewed as a whole, and a few isolated instances over a period of years will not amount to cruelty. The ill conduct must be persistent for a fairly lengthy period where the relationship has deteriorated to an extent that because of the acts and the behavior of a spouse, the wronged party finds it extremely difficult to live with the other party any longer may amount to mental cruelty. Next point. If a husband submits himself for an operation of sterilization without medical reasons and without the consent or knowledge of his wife, and similarly, if the wife undergoes vasectomy or abortion without medical reason or without the consent or knowledge of her husband, such an act of the spouse may lead to mental cruelty. Next point. Unilateral decision of refusal to have intercourse for considerable period without there being any physical incapacity or valid reason may amount to mental cruelty. Unilateral decision of either husband or wife after marriage not to have child from the marriage may amount to cruelty.
Where there has been a long period of continuous separation, it may fairly be concluded that the matrimonial bond is beyond repair. The marriage becomes a fiction, though supported by a legal tie. By refusing to sever the tie, on the contrary, by refusing to sever the tie, the law in such cases does not serve the sanctity of marriage. On contrary, it shows scant regard for the feelings and emotions of the parties. In such like situations, it may lead to mental cruelty. And if wife demands to live separately from husband's parents without a valid justification, then also it can be considered as mental cruelty.
This video is purely theory. The Honorable Court decides each case on merits.
Thank you.